Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving admission of bad character evidence, a key topic in criminal litigation under FLK2. Let's dive in. A defendant is facing charges in the magistrate's court for the theft of a bag of oranges from a supermarket. The defendant has a notable history of similar offenses, having been convicted on 4 separate occasions for stealing fruits from different stores. The prosecution argues that the repeated nature of these offenses, all involving similar thefts, is relevant to the issue of the defendant's propensity to commit such offenses and therefore seeks to introduce this history as bad character evidence. Can the prosecution introduce evidence of the defendant's previous convictions as bad character evidence? A. The previous convictions are relevant to an important matter, and since the convictions are for the same offense, they can be adduced without seeking permission or application. B. The previous convictions lack substantial probative value, therefore, they should not be brought before the court. C. The previous convictions have the potential to be relevant to an important matter in issue, and attempts should be made for the previous convictions to be before the court, after obtaining leave from the court. D. The previous convictions are relevant to an important matter in issue and can be adduced, even without substantial probative value or defense agreement. E. The previous convictions have substantial probative value, but they can only be adduced with explicit agreement from the defense. The best answer is D. The previous convictions are relevant to an important matter in issue and can be adduced, even without substantial probative value or defense agreement. Under Section 101(1)(d) of the Criminal Justice Act 2003, Gateway D, evidence of a defendant's bad character, including previous convictions for similar offenses, is admissible if it is relevant to an important matter in issue between the prosecution and the defendant, such as showing a propensity to commit offenses of the same kind charged. This does not require explicit defense agreement or substantial probative value, just relevance to an important matter in issue. So, in this scenario, the prosecution can introduce the previous convictions as bad character evidence because they are relevant to the defendant's propensity to commit theft, which is an important matter in issue in the current case. A is incorrect because, while relevance is required, the prosecution must still make an application. B is incorrect because the law does not require substantial probative value for prosecution use under this gateway. C is incorrect because previous convictions are relevant, not just have the potential to be relevant. Also, attempt should be made is not the correct legal standard. E is incorrect because explicit defense agreement is not required for admissibility under this gateway. Scenario 2. A defendant is charged in the magistrate's court with theft of a bag of oranges from a shop. The prosecution is aware that the defendant was convicted of 5 similar shop thefts 20 years ago, but has had no convictions since. The prosecution seeks to adduce the previous convictions as bad character evidence to show the defendant's propensity to steal. Which of the following best reflects the legal position regarding admissibility of this evidence? A. The convictions will be automatically excluded by the court as they are more than 10 years old. B. The convictions may be admissible, but their age will significantly affect their probative value. C. The convictions are automatically admissible as they relate to the same type of offense. D. The convictions may be admitted if the defense consents to their use. E. The convictions are admissible only in Crown Court proceedings, not in the magistrate's court. The best answer is B. The convictions may be admissible, but their age will significantly affect their probative value. Under Sections 101 and 103 of the Criminal Justice Act 2003, bad character evidence may be admissible to show propensity to commit offenses of the same kind. However, the relevance and probative value of the convictions depends on various factors, one of which is the passage of time. 20-year-old convictions may still be admissible in principle, but their weight is diminished because the defendant has stayed out of trouble since then. The court must consider whether the convictions are still probative of current behavior, or whether they are now too remote. Ultimately, the decision rests on the balancing test under Section 101(3) whether admission of the evidence would have such an adverse effect on the fairness of the proceedings that it ought not to be admitted. So while the convictions may technically be admissible, their age makes them less persuasive, and the magistrates might decide to exclude them in the interest of fairness. Scenario 3. A defendant is on trial in the magistrate's court for theft of a bag of oranges from a store. While giving evidence, the defendant states, "I've always been an honest person, I'd never steal anything." The prosecution is aware that the defendant has 2 prior convictions for making off without payment, one from 4 years ago and one from 8 years ago. The prosecution wishes to adduce these convictions as bad character evidence. Which of the following best reflects the legal position? A. The convictions cannot be admitted because they are different from the current charge. B. The convictions can be admitted because they are offenses involving dishonesty. C. The convictions are admissible as the defendant has given a false impression of his character. D. The convictions are inadmissible because of the time that has elapsed since the last offense. E. The convictions are inadmissible because the defendant has not been convicted of theft in the last 3 years. The best answer is C. The convictions are admissible as the defendant has given a false impression of his character. Under Section 101(1)(f) of the Criminal Justice Act 2003, the prosecution may introduce bad character evidence if the defendant has given a false impression of himself. By stating, "I've always been an honest person," the defendant has put his character in issue and created a false impression, thereby triggering this gateway. The prosecution is then entitled to rebut this false impression by introducing previous convictions, even if they are not very recent. This gateway applies regardless of the similarity or timing of the convictions. It is about correcting the misleading impression. This table summarizes the key legal principles we have gone through today. In Scenario 1, where someone keeps stealing similar things, the law says this kind of repeated behavior can be used against them in court. If the previous convictions are for the same type of offense and are clearly relevant, the prosecution can bring them up to show a clear pattern or propensity to commit that kind of crime. In Scenario 2, things get a bit more complicated. If the defendant's previous thefts happened a long time ago, say, 20 years back, they might still be allowed in as evidence, but the court will take a careful look at whether they're still relevant. The older the convictions, the less weight they usually carry, especially if the person has stayed out of trouble since. The court has to balance whether bringing them up is fair, or whether it would unfairly prejudice the trial. Finally, in Scenario 3, the focus is on what the defendant says in court. If they claim something like, "I've always been an honest person," and that's clearly not true based on past convictions, the prosecution is allowed to bring those convictions in, even if they're not theft-related or very recent. This is because the defendant has given a false impression of their character, and the law allows that to be challenged with evidence that sets the record straight. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.